It's highly unusual and unacceptable for a judge to kill a criminal inside a courtroom. Such an act would be considered a severe violation of the judicial ethics and the law. But most of the time, the judges have to declare the death sentences ruthlessly due to the intensity of the crime. So are you ready to know what's the whole story here? Well, in this video, we'll share with you the untold story of a judge killing criminals inside the court. Laws and morals are at a questionable stage right now. If one ought to walk the route of law, or whether one ought to walk the path of morality. If one were to base their decision on morality, then there would be no fair resolution to the conflict that involves both parties. Therefore, one should go with the law, even if doing so would bring up questions of morality once again. To provide one example, an advocate's morals would be compromised if they defended a client accused of rape, and the same thing serves as a barrier to the possibility of the accused being given the death penalty. Because of this, India has a relatively low execution rate when compared to other countries. Despite this, there has been a steady increase in the proportion of death sentences that have been proven to be carried out in India since the year 2016, with 65% of all death sentences having been carried out. In India, the death penalty is reserved for the most extreme and exceptional of criminal offenses. When it came to deciding whether or not to impose a death penalty, several precedents were up for debate. The Supreme Court of the United States, in the case of Ediga Annama v. the State of Andhra Pradesh, 1974, established the notion that the standard punishment for the crime of murder is life in prison, with the death penalty being reserved for exceptional circumstances. In addition to this, the court ruled that if the court were to decide to impose a death penalty, there must be a compelling basis for doing so. In the case of Bachan Singh versus the State of Punjab, which took place in 1980, the issue of whether or not the imposition of the death sentence constitutes murder, according to Section 302 of the Indian Penal Code, was brought up. Another topic that was brought up about this case was the following: what kind of situations qualify as extraordinary circumstances warranting the imposition of the death penalty? It's been decided by the Supreme Court of India that Section 302 of the Indian Penal Code is legally legitimate, and therefore putting someone to death would not be considered murder. According to what was said, the imposition of the death sentence should be reserved for the most exceptional of exceptional and cruel of situations. According to the statement made by the bench, there are a variety of factors that support the imposition of a more lenient punishment. The judiciary should not have a taste for blood. The issues that has to be answered now is how to identify the rarest of rare situations. Two conditions must be met for this to be the case. Number one, there must be severe responsibility on part of the offender in the commission of the crime of murder. And number two, there must be extreme cause on the part of the offender in the commission of the crime of murder. The death sentence is also imposed after considering both the reasons that contribute to the severity of the crime as well as any mitigating circumstances. The case is known as Vinay Sharma versus the Union of India 2020. The case of Vinay Sharma versus the Union of India, more often known as the Nirbhaya gang rape case, has shaken the composure of the whole nation. The tragedy took place aboard a bus in the chilly weather of Delhi. The girl was murdered in addition to being violently raped by the 6 suspects, which resulted in the girl's death. In addition to this, an iron rod was pushed into her intimate areas, and then she was thrown nude into the road. Her death was a direct result of the emotional and physical torment that she endured. At the time that the matter was brought to the court, one of the accused had already committed suicide in prison, and since one of the accused was a child, the judge decided not to condemn him to death. However, the remaining 4 defendants were all found guilty, condemned to death, and executed by hanging in the year 2020. Following an examination of the contributing variables, this conclusion on the appropriate punishment was arrived at. The variables that made the situation worse were more significant than the ones that may have helped. The pertinent facts of the crime, including the victim having been subjected to inhumane torture, led to the conclusion that the only appropriate punishment was the death penalty. The victim's death was a direct result of the perpetrator's actions. The Shabnam case against the Union of India 2015. In the case of Shabnam v. the Union of India, the lady was given the death penalty by the court, and she was the first person to be executed by hanging in the history of the Indian criminal justice system. In this particular instance, Shabnam and her boyfriend were responsible for the deaths of her family members. The year 2008 saw the occurrence of this event. Shabnam murdered her family members since they would not provide their consent for her to be wed to her boyfriend. As a result, she plotted a gruesome murder for her family, which ultimately served as the contributing element to the crime. In addition to not leaving her infant nephew, who was only 10 months old at the time, she also caused him to be covered in blood. She also pleaded for compassion from the president, but her request was denied and she would likely be executed within the next year. Hyderabad Veterinarian Case, 2019. In the instance involving the veterinarian in Hyderabad in 2019, the female doctor was in the scooter by herself when she parked it at the Shabnam Plaza. From there, she got a cab to the workplace where she was trying to go to work. Meanwhile, 4 of the accused were keeping an eye on her, which is what prompted them to puncture her scooter when she was not around. She noticed that one of the tires on her scooter was flat when she got home from her job. And in the meanwhile, the 4 suspects had arrived and immediately began abusing her, including raping her and setting fire to her body. The circumstances surrounding the crime were such that a death sentence should have been handed down. Yet, the police were able to speak with the accused, which raises doubts about the Indian legal system. National Capital Territory of Delhi against Siddhartha Vaisht and Manu Sharma, 2010. Siddhartha Vaisht and Manu Sharma v. the State, also known as the Jessica Lal case, was one of the horrifying death cases that led society to realize that money can sometimes buy anything, but it cannot buy justice. The case was one of the horrifying death cases that led society to realize this. In this particular instance, the girl was killed by gunfire when she refused to provide alcoholic beverages to one of the suspects. Her sister was forced to seek justice for her sister in every court possible. And eventually, via a media trial, she was successful in persuading the Suo Motu case to be transferred to the High Court. In this particular instance, the accused utilized deception to turn the most important eyewitnesses against him, which is one of the reasons why the judge decided to sentence him to life in prison for his crime. This conclusion was reached after taking into account the relative weight of the various aggravating and mitigating variables. Surrender Kali versus the state of UP. In the case of Surrender Kali v. the state of Uttar Pradesh, which is also well known by the name Nithari Kand and took place in the year 2007, was one of the most stunning pieces of news for Indians at the time. In this particular instance, the dead bodies of both children and adults were discovered at the residence of Mohinder Singh Pander, which is located in the area of Noida, known as Nithari. After an in-depth investigation into the case, it was discovered that the girls' bodies had been raped, murdered, and eaten by the perpetrator before their bodies were found. After committing such a heinous act against 15 young women, he was sentenced to the death penalty. He qualified as one of the aggravating elements in the case. However, by the terms of the plea bargain, he will serve the remainder of his life behind bars. In the annals of the Indian criminal justice system, these are the few truly horrific deaths that have ever been investigated and prosecuted. There are many cases such as the Hathras gang rape case and the Arushi Talwar murder case and the Unnao gang rape case, in which the investigation or final judgment is not yet complete, but a death penalty is required as a punishment for the seriousness of the crimes committed. The establishments of these precedents serve as a model case to prevent such heinous occurrences in the future, and perhaps most significantly, the right balance between circumstances that are aggravating and those that are mitigating should always be taken into account when deciding how to rule in such circumstances. So that concludes our video. Please share with us in the comments below. Give the video a thumbs up if you liked it, and make sure to subscribe to our recent channel for more videos like this. See you at the next one. Until then, peace.